Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Maritime Law, Introduction to Shipping Laws, Singapore Law Watch. Liens. There are generally three types of lien relevant to admiralty law. First, maritime lien, two statutory liens, and the third is possessory lien. First, maritime lien. 25.3.13 A maritime lien is an encumbrance or charge on the rest, which accrues from the moment the underlying claim giving rise to it attaches, travel with the rest, survives any change of ownership of the rest. Except one that is consequential upon a judicial sale and is carried into effect by an action in rem. As a general rule, a maritime lien enjoys a higher priority than other kind of maritime claimants. The establishment categories of claims which give a rise to maritime liens are salvage, damage done by a ship, master wages, master disbursements, and crew wages. 2. Statutory lien. 25.5.14 A statutory lien refers to the right of claimants to invoke the court's admiralty jurisdiction by means of an action in rem in respect of a claim which does not attract a maritime lien. Claims which can be enforced by way of a statutory lien are set out in S 3(1)(a) until R of the HCAGA. Although it is the arrest that gives a claimant his prejudgment security, the institutions of the action in rem start with the issuance of the writ in rem, and thereupon the statutory lien attaches to the ship and survives any change of ownership by remaining enforceable against a bona fide purchaser of the ship without notice unless the vessel has been judicially sold. 3. Possessory lien. 25.5.15 Unlike a maritime lien, a possessory lien is only effective if the person seeking to enforce it against a chattel comes into possession of the chattel lawfully and retains it uninterrupted possession of the chattel. A possessory lien is a creature of the common law. It is not accompanied by the right of the sale, unlike a pledge, nor does it confer any titles of the holder. Unlike a mortgage, the lien usually accrues to the benefits of a party who has rendered improvement or repairs to or otherwise done work on the chattel, such as ship repairer or the salver in respect of property successfully solved. 25.5.16 The fact that a ship is subject to a possessory lien cannot, however, prevent it from being arrested. The lien is not extinguished when the vessel is arrested by a party other than the lien, as arrest only transfer custody and not possession of the vessel to the sheriff. 1. Relative priority between claims. First, the rules of priority between claims are procedural and important where the sum of the claims exceed the value of the rest and determine the order which claims are satisfied. 25.5.17 The relative priority between claims is a vital issue when the sum total of the claims exceed the value of the rest, as it determines the order in which these various competing claims will be satisfied Out of the funds, lying rules of priority are characterized as procedural and are therefore governed by the lex fori. Second, the order of priority. 25.5.18. If there are various claims to the proceeds of sale of the rest, the prima facie ranking of claims in order to priority is as follows: sheriff's expenses, cost of the producer of the fund, maritime lien, except for a possessory lien which accrues before the maritime lien, possessory lien, mortgage, and statutory liens. 25.5.19. The prima facie order of priority set out above is not immutable. The courts have discretion to alter this order where there are special circumstances that warrant. However, there must be truly exceptional or special circumstances, and the departure from the established order of priority must be essential to prevent an obvious injustice. In deciding whether exceptional circumstances are present, the inquiry will usually focus on the conduct of the party whose priority is sought to be disturbed in relation to the other competing claimant. Various aspects of merchant shipping and oil pollution legislation of Singapore. A. Limitations of liability of ship owner. First, limitations of liability covered by Part 8 of the Merchant Shipping Act. 25.6.1. Limitations of liability of ship owner for maritime claim is dealt with a statutory under Part 8 of the Merchant Shipping Act, such claims include those for death or personal injury, loss or damage to goods occurring on board in connection with the operation of a ship. 2. Limitations of Singapore is governed by the Conventions of Limitations of Liability for Maritime Claims. Singapore implemented the Protocol of 1996 to amend the Convention on Limitation on Liability for Maritime Claims on 29 December 2019, pursuant to the partial commencement of the merchant shipping. The 1996 Protocol updates the limit of liability under the Conventions on Limitations of Liability Maritime Claims. The implementations of the 1996 Protocol does not apply in relation to any liability arising out an occurrence that took place before 29 December 2019. The test of the requirement for breaking limitation for the 1976 Conventions and 1996 Protocol is essentially the same. For liability arising out of an occurrence which took place before 29 December 2016, the 1976 Conventions of the 1957 International Conventions relating to the limitation of the liability of owners of sea-going ships apply prior to the Merchant Shipping Act to the 2004. The regime for limitations of liability based on tonnage of the vessel was the 1957 International Convention. With the amendment in 2004, Singapore ratified the 1976 Convention. The 1976 Convention only applies to liability arising out of the occurrence that takes place after 1 May 2005. And liability arising out of occurrence which took place before this date continues to be governed by the Convention. So this is the end of the article. Don't forget to watch the previous video and bye bye.